Hi there, it's John Crotts with King Law, attorney and elder law specialist. Going to talk to you today about partition in North Carolina. If you've inherited property or somehow ended up co-owning property with someone and can't get along with them on how to go about dividing that or managing that property, then partition may be something that you want to consider. So here's what tends to happen in these situations. Maybe a parent or a grandparent left some property through their will or a trust, or maybe they didn't even have a will and you just inherited property as their heirs, and you are trying to figure out what to do with that property. You may own a third of it, you may own a fourth of it, you may own a sixth of this property, and no one's going to agreeing on what to do with that property. So you could all agree to sell it and divide the money up. That's usually the easiest way to handle these things. You may agree that one of you can buy out the other, or maybe you get along so well that you can rent the property out, share the rental income. Any agreed upon solution among the family or among the owners of the property is great. But problems tend to develop over time, especially as family members pass away. I like to say this problem can compound over generations. Instead of 3 or 4 people owning it, suddenly there's a dozen or more who own this property, oftentimes family land. And eventually there's likely to be disagreement on what to do. So if you can't reach agreement on what to do, then the court is there to help you determine what to do. A petition to partition real estate is a special proceeding before the Clerk of Superior Court in North Carolina, and the court really has a couple of options. They can either order that the property be physically divided up into shares. This is more doable with large pieces of real estate, large pieces of land. With smaller pieces of property or a house and a small lot, it's kind of hard to divide that up, right? So in those cases, the court is more likely to order a sale. If there's a way to actually physically divide the property up into shares, the law actually favors that over selling it. But more often than not, it's not feasible, and the court has to sell the real estate. And after a hearing, and where documents got filed, documents got served on family, and family or people who co-own this property together are suddenly suing each other to figure out how to deal with this real estate. There's this awkward legal proceeding that can develop, and after that hearing, the court may order that the property be sold. And from that point forward, the proceeding looks a lot like a foreclosure proceeding. The property can be sold either by public or private sale, which means it can be auctioned off on the courthouse steps. Not usually the best way to sell property and get the best value out of it. Or it can be sold through some type of private sale. Realtors can be hired to market the property just like any other real estate sale. But once an offer comes in, that offer gets presented to the court, and it's subject to upset bids for 10 days. So if somebody wants to come along and bid up the property, they can. And every new bid triggers another 10-day period. So that's pretty much how that proceeding works. It creates, obviously, attorney fees, court fees, and really a lot of delays on how you can get to some type of resolution. So private agreement, much more beneficial for everybody involved. But once again, sometimes families don't get along, and that's what the court's there for. So petition to partition could be a way to clean up that old family real estate that you've been trying to figure out what to do with when you can't agree with your other family on what to do. If you've got questions about partition or anything else related to estate planning, elder law, anything of that nature, give us a call at King Law. Be happy to talk more with you. Talk to you next time.